Without any further ado, I'd like to welcome Kay up. Kay's an IT lawyer and has spoken at the group a number of times. And I'm quite embarrassed to say I've never been to one of Kay's talks before. So tonight's my first night, but I only hear good things. So welcome Kay up.
I see Brendan's going to transform your email in 30 minutes or less. That means that I've got more time to talk, which is a good thing because lawyers like the sound of their own voices. Listen, I did want to make this a fairly interactive sort of thing for you anyway. So if at any point you do have questions and things like that, just put up your hand and I'll try and fit them in. If they're really, really hard, then I might just not answer them. But, you know, we can always try and see where we get. Today I wanted to talk about risk wrangling, because we all have risk. Risk is everywhere. People sometimes ask me, you know, the whole point of having a lawyer is because you want someone to give you a silver bullet to make yourself unsuable. And I always have a great piece of advice. I've never yet had a client take me up on it, but one way to really bulletproof yourself against getting sued is go and put on a hair shirt and go and live in the cave after having signed over your worldly possessions to your lawyer. Apparently that's a conflict of interest, blah, blah, unethical, whatever. But, you know, look, the only way that you're going to be absolutely risk-free is to not be in business, basically, and not set foot outside your house. And even then you might get evicted. But apart from that, if you are in business, you're going to have some risk. The more activity you do, basically the more money you're earning, the more likely it is that you at some point will have some dispute, have somebody targeting you for something, have some misunderstanding over a contract, all that sort of thing. The more activity you have, the harder it is for your compliance to keep up, because there's more laws, the bigger your business is, the more difficult your tax becomes, the more your business expands. If you're going overseas, then you've got another whole can of worms that you've just opened up. So, what I wanted to do today is talk about the ways in which you can get sued, which is a very, very, very popular topic. Let me count the ways. Basically, when we talk about sources of risk, and this is just in general terms, it's like general law. You might be negligent, you might be fraudulent, something like that. At general law, you could get sued by somebody. You could be sued as a result of a contract that you've entered into. You might be sued or you might be pursued by authorities because of legislation. Because there's a lot of legislation that applies to you whether you know it or not. There's Australian legislation like Corps Act, Privacy Act. There's overseas legislation that might apply to you if your services are overseas, if your users are overseas, if your suppliers are overseas, if your activities are overseas, if you have an overseas branch and so on. There's criminal law, which is part of legislation, but a whole lot more harsh because you actually end up in jail. And then there's mere threats of litigation. And why I put that as a separate thing is because, look, for a lot of people, you will never see the inside of a court. I rarely see the inside of a court. That's because my whole aim in life as a lawyer is to stay out of court. I do this by trying to sort out all my client stuff before they get there. But most of you will never see the inside of a court, but you may very well be on the receiving end of some threat of litigation. It stresses you out, and it might mean that you have to spend money getting your lawyers involved to see whether or not you know, it's a real threat or not. So, I guess what I wanted to talk about was to give you some general perspective on how to identify sources of risk. And really, Each relationship that you have, let's set aside some of these. I'm assuming that you're not going to do anything criminal, I hope. By the way, I don't do crim. I hope that you are not going to do anything negligent or fraudulent, that you're actually competent at your jobs. For most people, they're not the key issues. For most people, it's more like they've breached the contract or they might be in breach of some legislation. So what I wanted to do today is just talk about some of the key ways in which you can identify what risks might arise out of contracts and some legislation. So I guess out of every contract that you have, out of each relationship that you have, there's some potential for risk, right? The more key those relationships are, the riskier it is for you. Because if it is a relationship which is absolutely vital to your business and you must have that relationship and you must maintain just that relationship and there's no other way of getting around it, if that one's derailed, you're in really big trouble. So for your upstream contracts, it's looking at your key providers and suppliers, the ones that you can't do without, the ones who are really important to you, the ones that you have a lot of dealings with. Be aware that even if you don't have something in writing, you still have a contract. Why? Because you do. You have an arrangement with them. That is, you have a contract. It might be verbal. It might be in an exchange of emails. It might be a handshake. It might be just because that's the way you've always done business. There might be some terms that you clicked on at some point, but you didn't read them because, you know, you figured that they were always standard anyway, and you just went, yes, fine, accept. Whatever the terms of that contract are, there is a contract between you and the other side, where you've agreed to do something, they've agreed to do something. They might have agreed to provide you a service and you pay them money, for example. So then, identify who are the key providers in your business. Are they the ones who do things for you? I know most of you are designers and builders yourselves and developers, but you might subcontract some of that work to others. You might have people who are content writers or artists, photographers, and all that sort of thing. You might have people who do some of the technical side of things, hosting or payment gateways. So then look at what are your key risks for those relationships. If it's someone who creates something for you, one of your key risks is intellectual property. If they create anything for you at all, or provide you with content, or provide you with materials that you're going to use or license on, make sure that you have the rights to do it, whatever it is that you want to do with it. For as long as you need to. For as many people as you need to. Don't assume that someone designs or takes a photo for you and hands it to you. Don't assume that you own the intellectual property in that photo. Don't assume that if they've given you a license that you can sub-license that right to somebody else, for example. You have to look at what the likely effects of breaches are. So if you've got a key relationship, then have a look at, well, what happens if that relationship breaks down? How important is this relationship to me? Should I have a backup? And then, of course, the other things that, I think last time I spoke here, I talked about what was in an IT contract. All of those things, all of those sorts of things are relevant to you here. When you're looking at any contract, how long does a contract go for? How does it define your liability? What jurisdiction applies, and so on. I particularly wanted to talk to you about cloud and hosting. Hosting overseas. Look, a lot of lawyers are really, really conservative. We're conservative by nature because a lot of my job is to tell people how to avoid risk, right? Avoid risk at all costs, just avoid risks. So I don't care if you think that cloud provider is really cheap. Just avoid them because, you know, it's just so risky because it's cloud. I know a lot of lawyers are like that. I'm not, because you make business decisions. Some of them are risky, some of them are not, right? But you make business decisions based on the pros and cons up and go, yes, it's worth it, or no, it's not worth it. But risk is one of the things that you have to balance up for yourself. So, what's wrong with hosting overseas? Well, if you are dealing with someone who is based overseas, one of the key issues you're going to have is that whole fight over jurisdiction. Number one, if they're based in the US, or if it's a US company, even if the servers are not there, if it's a US company, then US law will probably apply to the contract. The contract will probably say that US law applies. The contract will probably say that the USA, or whichever little bit of the USA, is the jurisdiction that applies. So if you wanted to sue anyone over that contract, you would have to go there to institute proceedings. Very, very expensive. Even if jurisdiction is not such an issue in you having to go there, even if you were able to sue them in Australia, you would still have to enforce that judgment in the US against the US corporation. So there's no real getting around it, even if the jurisdiction is Australia. If you want to enforce an order, you still have to go at some point to the US and take some steps there. It can also make it harder to identify the corporation that you're dealing with. This is especially true when corporations have a lot of branches and it's a group. So you're not really entirely sure if you're dealing with this arm of the group or that arm of the group or some subsidiary of something, something, something. It becomes more difficult to pinpoint what assets they have, what track record they have, what credit rating they have. All of those issues in assessing whether or not you want to deal with somebody become much more difficult when they're in a different country. It's difficult, it makes it more difficult in the practical sense to interact with them. So, I mean, you guys know this more than I do because you do this on a day-to-day basis, but you have to figure out whether or not, if something goes wrong, whether or not you can actually get hold of a human, and can you get hold of a human during your waking hours instead of theirs. And also, finally, I just wanted to talk about government intervention. Again, it's because overseas laws will apply, and that may be so even if I'm picking on Americans because, for example, I went to an Amazon Web Services sort of show and tell, and they're trying to establish a client base here in Australia. The servers may be based maybe physically in Europe or Singapore or somewhere in the States, wherever it is that, whether or not you state what region you're in, you want to be hosted in or not, or your data may go from here, 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 and here. They weren't at the time making any data centers here in Australia at the time of the show and tell. And I said to them, well, so if we signed up with you, what would stop you from, say, ending the contract with a month's notice, which your terms allow you to? And they went, well, we wouldn't because we're the good guys. And I went, that's not the answer I was looking for, thanks. It's that sort of thing. And government intervention may apply even if the server was in Australia, because by virtue of the fact that they are a US corporation, US laws will apply to them. A lot's been said about the US Patriot Act, whether or not it would ever get used to seize data under different circumstances for whatever nefarious needs that the US government wants. Every country tends to have rules along these lines. The US is not the only one. Australia also has rules about when the government can and can't step in and seize data, or seize servers, seize equipment. But my point here is that it's a risk factor. So if you think that keeping up with Australian law is hard enough, try keeping up with a whole pile of other laws, which are constantly changing. Again, it's about assessing this risk and knowing how important or how vital it is, whatever it is that you're hosting with them. What would happen if it were suddenly taken away for whatever reason? And then sort of going, well, is the fallout worth it? How likely is it, and is it worth it? I wanted to have a bit of a talk about the downstream contracts. That is your contracts with your clients. So let's say a website. You've got different types of clients, different classes of clients. You've got some users who are just casual users. They just come on and browse. They haven't signed up to anything. They're just like flicking around whatever's publicly available. You've got the kind of users who are registered users who are paying you money often, or if not, they're at least registered so that you're interacting with them in some way and you've got some personal information of theirs, whatever it is that you're doing with them. And then there's other people who are like advertisers, or who are vendors, or other people who are maybe posting things or interacting with your site in some way and probably paying you. Ideally, somehow when you run a business there should be some money incoming involved. I'm just throwing it out there. So what are your key risks? Again, a lot of this is like from a practical perspective, and you guys know more about this than I do, but from a legal point of view, I always look at what are your users allowed to do on the site? What might your users do with your website content, right? What laws apply to your users, as in where are your users, and what laws apply to you as a result maybe of where your users are, of all those different types of users. Why is this relevant for you? Well, let's talk about a couple of recent cases about where there's been a bit of a recent trend. Instead of trying to nab individual users because they're hard to identify and normally broke and sometimes 15 years old and living in their mother's basement, a lot of companies, the plaintiffs, for one reason or another, have decided not to pursue end users. Instead, the much bigger target is the service provider. Well, you know, why would you go for ants? You'd go and get the ant's nest, wouldn't you? So let's have a look at some of the recent cases. IINet's a big one. It was a really big one, very hard fought over a number of years. The good news is that IINet was found not to be liable for copyright infringement done by its users. So individual users who were, even if IINet kind of knew in theory that people were sitting at home and downloading illegal movies and things like that, IINet didn't encourage it. They didn't condone it. They did have it in their user terms saying, you know, you shouldn't be doing that stuff. But the court held that IINet did not have a duty to actively go and stop those users from doing the wrong thing. But part of that reasoning was because the court said IINet doesn't control individual people's PCs at home. So they don't know what you've got on your home computer. They don't know what you've got on your servers. So even though you're using their services as an ISP, because they didn't have any control over the end data that was being transmitted, and they didn't have any control over what people wanted to do, and because all they had was, they couldn't even identify which individual was doing what. They could only say, some person at that IP address is doing X. And that's about all they could, that's about all you could tell. In my household, I have 6 teenagers, so God knows I don't, yeah. So I'm probably one of those households where stuff goes on and it can be any number of users. And you couldn't sort of go, well, just because I'm the account holder, it's me that's doing it. It's not me. I'm legit. I'm a lawyer. But IINet was held not to be liable for that. However, for a lot of my other clients, they're in a slightly different position where they're hosting the data on their servers, or they're hosting the data on a third-party server. But they have control over the data. So they may be in trouble despite the IINet decision. Because they are hosting the data, they may still be liable for whatever their users are doing. IINet does not get them off the hook. Optus NRL, that's another big case. I don't know, has anyone heard of it? Yep. So Optus NRL, and I don't follow sports much, but it seems that what Optus wanted to do was have a system where people could record a game. It would be stored on Optus's servers, and then that user can replay it at their leisure. What the court at first instance has held is that Optus is liable because, technically speaking, that's copyright infringement. You're making an illegal copy of a program. And technically speaking, you shouldn't be allowed to. So even though it's the user that's doing it and pushing the record button, Optus is liable for those actions. It's on appeal. We'll wait and see. But it's another instance of where, look, you're not doing the wrong thing, and if that person did it in their house and used a PVR or something like that and recorded the game, that would be perfectly legal. But because they're doing it on your servers, it makes you liable for copyright infringement. Who knew? Perth Online, this one you might not have heard of. It was a fairly small case, but it was a case where an online version of a newspaper ran a story about 4 kids who had hijacked a car and then driven it recklessly and killed themselves. Tragic story, and the people who commented on it made really racist and very defamatory statements about the boys, the upbringing, the families, their mother, and so on. The site's comments were moderated. So all of the comments went through to the moderator, and the moderator let it through, thinking it was a valid comment. Newspaper was done for defamation. Again, it wasn't the newspaper that wrote the comments, but by letting it through the moderator, they republished it. They were liable for the user's actions. Google sponsored links just recently. Google's gotten into a bit of strife in Australia again. These are Australian cases except for the last one. Google's gotten into trouble because people were taking out sponsored links that looked misleading. So Google didn't take them out, but say I run car company A and I take out a Google sponsored link for car company B. That's what they did. So when you click on, so someone's looking for a Ford, they click on my link, and it takes them back to the rival car company or car yard. And it's not the person who's advertising like that that's been penalised for doing the wrong thing. It's Google, because Google allowed it. Again, that one's, I believe it's on appeal, and we'll watch that one as well. Mega Upload, which I'm sure you've all heard of. Look, this is an interesting case where you've got, as I understand it, it is a .com. The website itself is megaupload.com. Mega Upload CEO is a German national, Kim.com. He was residing in New Zealand. The servers were hosted in Hong Kong. but it didn't stop the US authorities from getting the New Zealand police to arrest him and freeze all of his assets worldwide. Now, he's since unfrozen some of it, and he's been a little cheeky back to them, and look, he's a larger-than-life sort of character. But what I'm saying is that in this sort of instance, he hasn't yet been dragged back to the US and formally charged with, I can't remember what it was, that racketeering, I think it was. But he's got to fight that. He's got to fight that case now. It's a jurisdictional issue, and it's one that I'm really going to be watching very closely, because it's where the US authorities have insisted that he somehow comes under their jurisdiction. Their latest argument was he comes under their jurisdiction because Mega Upload has done business in the US before. So therefore, he's under the fact that he's a .com. They've previously argued that sort of thing. You're a .com, therefore you're under our jurisdiction, for example. So, did anyone have any questions at this point? Yeah.
So the Mega Upload stuff, they alleging that he has committed crimes in the US?
Yes. In the Mega Upload case, what the U.S. government, the feds, are alleging is that Mega Upload provided a file locker sort of a system. People were uploading pirated content. Mega Upload knew that they were uploading pirated content and making illegal copies. Therefore, the illegal copies are sitting in Mega Upload's servers in Hong Kong, and then they're downloading them or sharing links or sharing that information with other people. And on such a scale that it was criminal charges for copyright infringement and racketeering came out of that. As I understand it, the racketeering charges will sit on top of the copyright infringement. Yeah. Yep.
With your example for Google, is that similar to the first online in that Google actually vet all the ads in the same way that the first online were vetting all the comments, or is that?
The question was whether or not the Perth Online reasoning and the Google Ads reasoning was similar, in that, is it because Perth Online vetted the comments and then Google Ads vetted the ads, therefore both are liable? I don't think it's that simple. And as I said, the Google ones are still on appeal. Even the Perth Online one, because it's defamation, it's slightly different again. It's more about republication as well, where the copyright infringement, you're talking about authorization of the copyright infringement. So slightly different.
But the liability thing is still...
Is the liability because are you more liable because you moderate comments? Indirectly, yes, which is the weird thing. You know, you want to get rid of the really awful stuff, so therefore you moderate, but because you moderate, you are more liable because, hey, you moderated and you let it through, so, you know, obviously you authorized the ones that got through. It's a really, really hard one. To moderate or not to moderate. If we look at the older cases, there's some old bulletin board sort of cases where bulletin boards that didn't moderate at all were held to have a lower level of liability because in their terms they said, we don't moderate, we don't do anything, we do nothing, hands off, whatever you do, it's all at your own risk, blah, blah. And they were held to a lower level of liability than ones who said, we moderate, man, we edit, we do this, we do that. Yeah, so it's a really difficult one. For my money, I think that you should moderate the really worst stuff. If something's sitting on your site, even if you have a stated policy of not moderating, if it's really obviously bad, I'd still like quietly dump it. And somewhere in your terms say that you don't moderate, but you have the right to moderate if you want. But I wouldn't let I wouldn't let defamatory stuff sit on my website because, you know, as I said, this is about risk. Even if you are held not to be liable for the defamation, right? Even in the end, if in the end you win, you've still lost because you've sold your house to fund the defense, right? So really, if we're talking about how, what level of risk and how to assess the risk yourself, think about how to take steps to avoid having to be dragged through court anyway in the first place. I think common sense would be if something was really bad, you just dump it off your site or your Facebook page. I know the Queensland Police got in a bit of strife just recently because with the Brookfield murder case of Alison Baden-Clay, the police, QPS Media, do a really good job because they do interact with the public, and I follow them quite a lot, both on Twitter and Facebook. But they made an announcement about who was arrested, about the actual arrest. And all they said, they didn't name anyone, they just went, a man has been arrested in relation to that murder. And people were immediately flooding the site with all sorts of comments, you know, about speculating on his guilt or otherwise. And a lot of them would have contained information or comments that were prejudicial to the case, which shouldn't really see the light of day in that sort of forum. QPS were trying to delete them as fast as they could, but they couldn't turn the comments off in Facebook. But anyway. So for each of these risks, I guess, just to give you, and this is, look, you guys know more about risk assessment than I do, I'm sure you do. This is really basic stuff. What is the risk? How likely is it to happen? What are the possible consequences? And again, we're not here talking about actual liability or potential liability, but even just the potential that you are going to get that threat of litigation that you're going to have to spend money and time and effort and stress out about. That threat or getting dragged into a dispute even before you get to the actual nuts and bolts of are you actually liable for this, okay? What are the possible consequences? Are there any possible backup plans that you can take to avoid it? Are they worth doing? And am I getting paid enough to take this risk? Because you know what, that's what it's about. You can take all sorts of risk. You can do a business that's super, super risky, and if it's worth the money, and you think it's worth the money, you would do it. That's why there are drug dealers. On the legal side, some steps to minimise risk. If you're setting up a business, structure it the right way. Try and avoid being a sole trader. For God's sakes, don't be a partnership. That's so bad. If you want to know how bad, come and see me later. There are all sorts of things that you can do. Many of them are tax-driven about different companies and trusts and combinations of them. But really, the whole aim behind structuring is to remove the risk from your assets. Your assets being the business assets. You might be running a business, say, with 4 different arms, for example. If they're high-risk sort of businesses, you might want to put them under separate companies, because if one goes down, then it won't take all of them down with it. Whether for insolvency or getting sued for something or other, you know, or a little old lady falls over in your coffee shop and you find out your insurance is lapsed. If you have personal assets, try and have the person who owns the personal assets not be the person with the target printed on their forehead. But if you're going to stick it into a spouse's name, make sure you get on really, really well with them. Because I have also seen that go down really badly. Contracts with each other, making sure that you know who you're dealing with. So within each of those structures, who owns what bit, who has control over what bit. Make sure that the relationships are very clear and very strong. Contracts with outsiders. making sure that all of those contracts that we talked about, your supplier contracts, your client contracts, your contracts with employees and subcontractors and anyone are clear. You might choose to do some handshake type contracts, that's up to you, but typically handshake contracts are contracts that are poorly verbalized really because they're really, really vague. That's why you shook hands on it, because all the details were really vague. For my money, I think that the more the contract is worth, the more important it is, the more essential it is to you, the more money it's worth, the more specifics you should have down. Who's delivering what, when, how, where, why, and how much money is changing hands, and have it right down so that there's no misunderstandings. Internal contracts and policies, this is more to do with governance for your own staff, for example, whether you've got a social media use policy and things like that. Intellectual property, again, any intellectual property that you create, make sure that you have a really clear idea of who owns it and who's got the right to use it and how far those rights extend. So in other words, don't create something for somebody, sign off your intellectual property rights, your ownership, and then find out the next week you really needed to use that bit again because you got another client with exactly the same thing, and geez, you could have saved a lot of time and effort if you had still retained ownership of that thing that you wrote last week and reused it for client B. And charge the same again, of course, as you do. It's also about checking who you're dealing with. I don't know, do you guys have some standardized way of checking what entities you're dealing with when you're signing up a new contract? When you sign up a new client, do you actually go and do a search on them?
We normally check the business structure.
You check the business structure?
Yeah, it tends to be indicated for our customer.
That's it, you should check.
And if we're fishing in the approach.
That's it. I don't know of that many companies that actually habitually run credit checks, but at the very least you can just check ABR lookup or ASIC just to check that the company exists and is valid for starters. You might want to do an ASIC check if it's a big enough deal to find out who the current directors and shareholders are. Then you know who's behind the company and whether the person who's signing your contract is actually a director as he says he is or not. Maybe he's a janitor. I always recommend to my clients where possible that they just put in some common sense technological methods to enforce their rights. For example, like a remote kill switch in software. Or if you're going to host something, say for those of you who are web developers, to do things like control where it's hosted and how, so that you still maintain some control at least until you get paid. Balance your workflow with your cash flow. Again, this is a business process thing rather than a legal, but if you're going to develop something for somebody, don't hand over the entire thing and go, yeah, here's your standalone solution, thanks very much. Now can we get paid for the last 6 months? Yeah, because we hadn't been paid anything. And you'll find that they're still implementing it and you still haven't been paid because they'll come back with, yeah, well, that we found a fault in it and yeah, so we don't think you should get paid because we found this little tiny fault. Well, I mean, most of it's usable, but because of this fault, we don't want to pay you. So it's all about balancing, using your business processes to balance that cash flow with your workflow. Any other questions? Anyone? You're a very quiet mob. Here's a list of people that you should have really good contracts with. Of that list, I've got shareholders on the list because it's the contract between shareholders that's important, so that you've thought about what happens if somebody wants to quit, what happens if they get sick, what if they want to just butt out altogether or sell out, or what happens if they die, as well as who gets to run the company, how do you vote on things, who gets to be a director, and so on. Employees of this list, if you had to do away with any set of terms, it'd be employees, and only because there's a lot of other law that overrides whatever you write anyway. So you can say, yes, employee, thou shalt work 23 hours a day with no break and get paid 1 cent per hour, and it would get struck out. So of all of these, there's more of a settled body of law with employees, but not so much with the others. Contractors and subcontractors, apparent, again, it's that common sense. It's that, what are you getting in return for what you're paying, what your obligations are, what their obligations are. Post-contract, what the obligations are. How do you end the contract early? How do you end it if you're not happy with them? How do you extend it if you are happy with them? Same deal with suppliers. And of course, your customer and clients is mostly about balancing risk. So you look at what level of risk are you accepting under each of those contracts, and make sure that the level of risk that you are left with, standing between your customers and your clients and your contractors, the level of risk that you are left holding is worth your money. Does that make sense? So in other words, if your suppliers are offering more or a better SLA than what you're offering your clients, sweet, no problemo. If they are offering a lot less, and you're making up the difference in your personal call center, which is running from your bedroom, then you want to know that you are accepting that risk. You want to know that that's what we've promised to do. Make sure that you have balanced your contracts. So that's pretty much what I wanted to cover today. I wanted to know if there's any questions. Yeah.
Gives us an indication of how many people come to you who have basic risk covered.
How many people come to me who have basic risk covered? People come to me at many different stages of running a business. They come to me at the very beginning when they're just starting up, when they have nothing, just nothing. They'll come to me when they have been running for a little while, because they started off with some stuff. They do have contracts, sorta, which they Googled and then they cut and pasted from some stuff that looked really interesting, and so far they haven't had a problem until last week when somebody complained about something or other that they did, and then they come to me. So that's another sort of pressure point for coming and seeing a lawyer. There are more established clients who really have run for quite a long time. They have taken all of these steps, and they come to me for the first time because they want someone. They're launching some new product, or they're launching something which their current lawyer cannot understand, and they want someone who does more of that IT law, rather than they're going, well, we've got a business lawyer and he set us up, we've got our structure right, we've got all those risks assessed, but we're now doing something which our current lawyer is going, yeah, so what's cloud? And at that point they've gone, okay, we need somebody more specialized for that. So yeah, look, there's different, it depends on wherever it is that you are in your life cycle of your business, kind of thing. The people who have been running for longer, typically they've thought about a lot of these issues. People who are just starting out, they're not sure where to even start. Yeah. Yep.
What are any tips associated with managing risk to giving advice rather than making websites that say, I know the question is that insurance covers the cost of it being sued or something, but it's actually managing the risk of advising someone to do something a certain way, and then something else comes along and they say, you should have told me about this.
Okay, how do you manage the risk of giving advice rather than actually, so you're not someone who's actually doing the development yourself or the designing yourself, but you're advising somebody else. That's the boat that I'm in all the time, right? Where I'm advising people, do it this way, do it that way, do it this way, do it that way. The way that I manage my risk is by forking over a small fortune in insurance, which is all compulsory. But apart from that, it's also about qualifying your advice. If you're going to give advice, but there's some qualifiers. First of all, this advice is based on the background facts that you have given me, A, B, C, D, E. If any of these are wrong, tell me now, because my advice is based on that. Next, the scope of what you've asked me to answer is this question and this question. You haven't asked me to answer the sun, the moon, the stars. You asked me to answer this, this, and this. Next, we do not cover the following areas. For God's sakes, I did a business degree back in the 80s. That does not mean I can tell you about tax, right? Do not listen to anything I say about tax. The most I can say is, I think you've got a problem, and go and find an accountant. And I set that out in my advice as well. Because you have to state, this is the scope of what you're advising on, and this is outside the bounds. And that's about all I can offer. Beyond that, you sort of don't say anything really stupid. Yep.
I was going to say, in the weekend, I often deal with a lot of small businesses and startups, and one of the common things you see when people come here with ideas or new businesses that they're establishing is they all have a name for their business, so they bought a domain name or something like that, and they haven't done any sort of due diligence in terms of trademarks, and sometimes we just have a bit of a scope around on the IP register and say, we saw this, you should probably go talk to a lawyer before you proceed, because you could run into issues. But we don't work, so we don't know.
That's right. So it's one thing that you can do if you find that say at the moment there's a student, he's only about 24 in the UK, who was running a website which provided links to downloadable movies online. In the UK, under UK law, and he's a UK citizen and a UK resident, he is not breaking any UK law, because providing mere links to where you might find content, even if the content might be illegal, was not itself illegal at the time that he did it. I'm not sure about now. The US is still seeking to extradite him to the US. Why? Because some of the some of the content was owned by US companies, and some of the downloaders were in the US. Therefore, we have jurisdiction, yoink. And as far as I know, the UK is planning to hand him over. So, again, yeah, it does become a conflict of laws issue, but it also becomes an international incident that diplomats argue over. Yep. EU cookie laws, do they apply to your websites? The answer is, I don't know. Well, yes and no. Yes, they apply where you've got, and mind you, they've been in the EU for a long time, right? It's only that just recently, a year ago, the UK passed them, and it came into effect about 2 months ago in the UK. Really, it was a law that said that you can't have cookies on your site unless users agree to accepting your cookies. Technically speaking, yes, you should have been doing that already for any visitors to your site from the EU or the UK. In practice, they're going to come to Australia and try and fine you for not doing it. Doubtful. But it is, you know, if you want to be globally best practice, it probably is something that you should be implementing at some point in some form to whatever level you think is appropriate. Not that I'm suggesting anything. Yep. So I think that's all we've got time for. Thanks very much. Oh, wait. I have a book. Blogging and Tweeting Without Getting Sued. It is a book by a Mark Pearson, who has nicely autographed it for me. He's actually a professor of journalism, I think at Bond. But he's put together this book as a really handy guide. He has legal qualifications as well. He's gone through and gathered together all of the latest cases relating to blogging and tweeting and people who have gotten sued or otherwise online. It's pretty up to date because it's only just come out, but he's also on Twitter and he's tweeting cases all the time. I've got that up for grabs and Bruce is going to put it in the drawer.